All right, we are going on of the state of Michigan versus Xavier Smith, 24667. And Detective Lyles, if you can please state your name for the record.
Detective Matthew Lyles, MATTHEWLYLES, badge number 62.
Thank you. Please raise your right hand. Do you solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, thank you. You may proceed on the warrant.
Your Honor, on May 26, 2024, at approximately 01:14 hours, it'd be 1:14 in the morning, officers were dispatched to 17400 4th Street, apartment 106 within the city of Riverview. Upon arrival, officers made contact with the defendant, Mr. Xavier Smith, who stated he was trying to get a welfare check done on his girlfriend, who he had been in a dating relationship with for 1 year. It was later identified as the complainant, Laceria Jones. Officers were speaking to Mr. Smith, and there were some concerns that there may have been a domestic incident between Mr. Smith and Miss Jones. Officer Schramm just advised Mr. Smith that he was going to be detained for investigation of a domestic incident between the two, based on some comments that Mr. Smith had been having an argument with Mrs. Jones, but nothing physical had occurred. Mrs. Jones had not been located at that time. Officer Schramm was able to detain Mr. Smith after he had resisted arrest by pulling away and walking away, but ultimately complied and was handcuffed. Miss Jones was then located at the Riverview Police Department. She had gone and walked into the lobby to speak with an officer about a domestic incident between her and Mr. Smith. It was then discovered by Officer Miller that Miss Jones had dried blood on her mouth and shirt and some bruising and swelling on her face. Miss Jones explained that she had gotten into an argument with Mr. Smith, and Mr. Smith was telling her to lay down on the bed. Miss Jones was stated she was sitting up and drinking water and walking around when Mr. Smith was telling her to do this. Mr. Smith got angry at Mrs. Jones and started to choke her. Miss Jones then stated Mr. Smith struck her with a closed fist in her mouth, busting out one of her front teeth. This injury was observed by Officer Miller. Miss Jones stated that Mr. Smith then locked her in a closet, and he was sitting in front of the door, keeping it shut so she could not escape the closet. Miss Jones stated she eventually ran to the front door to leave the apartment while Mr. Smith was using the bathroom, and she walked to the police station to get help. Ms. Smith informed the officers that, Mrs. Jones informed the officers that Mr. Smith had stolen her iPhone, and she was able to describe it. Officer Miller observed the iPhone that was described by Miss Jones in Smith's property at the Riverview Police Department. Officer Miller took the phone, and Miss Jones knew the password to unlock the phone, as well as the phone was unlocked by facial recognition of Miss Jones's face. Jones went through her phone and observed that Mr. Smith had taken $150 from her Cash App account and sent it to his Cash App account, which was labeled $ God Xavier 999. Just to for the court's understanding, Xavier is Mr. Smith's first name. Ms. Jones showed Officer Miller the transaction receipt, and a photo of it was added to evidence.com. I later spoke with Ms. Jones, who stated, or who was very emotional and stated she was afraid of Mr. Smith. She stated she did not want to press charges, but asked if Wayne County would seek charges on her behalf in this case. That is all I have, Your Honor.
All right, thank you. Upon examination of complaining witness, I find that the offenses charged were committed, that there's probable cause to believe the defendant committed those offenses. I'm sorry, counsel, there's a second offense on the domestic violence and a fourth offense notice.
I'm sorry, Your Honor, are you speaking to me?
Yes.
Your Honor.
Your Honor, were you speaking to me? I got a couple people talking to me. Were you speaking to me, Your Honor?
Yes, Detective, yes.
Okay.
I just wanted to
Yes, Your
confirm
Honor.
that.
Yes, there are previous convictions, one on 8/19 of 2015, for a domestic incident. And then, Mr. Smith also has 3 prior, felony convictions on his record. One in 8/11 of 2010 for home invasion 2nd degree. One on 4/26 of 17 for carrying a concealed weapon, and one on 4/26 of 2017, for firearm possession by a felon.
May I state anything, Your Honor, or talk to my lawyer?
Hold on, just one moment, sir. All right, counsel, your
Yes, sir.
appearance for the record, please.
Good afternoon, Your Honor. Kurt Shemke, on behalf of my client. This time we consent to the matter being heard via Zoom. As to the arraignment, we waive formal reading and my client stands muted.
All right, thank you. Sir, your name for the record, please.
Xavier Smith.
All right, thank you. Please remove your hands from your pockets. All right, the court's going to waive the formal reading. Sir, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to one today, correct?
Yes, Your Honor.
Okay, please remove your hands from your pockets, sir.
Oh, sorry, Your Honor. Sorry.
Thank you.
Sorry.
You also have the right to be presumed innocent. Okay, you also have the right to be presumed, to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, I do, Your Honor.
All right, the court has also signed the order for court-appointed attorney for felony matters. The court's entering a plea of not guilty on your behalf, scheduling this matter for a probable cause conference on June 4th at 9 a.m. at the 28th District Court. June 7th, I think I just said 4th, June 7th at the 28th District Court at 9 a.m. And counsel as to bond.
Your Honor, my client indicates he's not on probation or parole, and although he does have prior history, he hasn't been in any sort of trouble, according to him, for at least 8 years. He currently resides in Riverview. He has 6 children, ages 11, 11, 9, 8, 6, and 6. He's actively involved. He works full-time at Amazon, so he indicates he will appear at any and all future court dates. And I'd ask you to determine an appropriate bond, potentially some leniency. He's indicated he's not a flight risk, and he is eager to find a resolution with this matter. Thank you, Judge.
Thank you. Yeah, yes, Mr. Smith?
Mrs. Smith, I say Mr. Smith. I think you were off the record of this case and what's going on. I paid off the rest of my rent. I think it was to you, Miss Elizabeth. Judge, Your Honor. And I received the paper. Yeah, I received another paper from y'all, and I was just letting you know I'm showing up to all my court dates that I had with you. I paid off what I was supposed to pay off. I can prove to you I'm not a flight risk. I know this seems like a big misunderstanding until I'm proven guilty. I won't be no trouble for the community or for Mrs. Jones. I do have family members that will support me if I have to get put on tether to go to someone else's house. I'm still making payments on my rent. I don't mind not being there because Ms. Jones shared that household with me. I do have, like I said, I do have sisters and aunties and other siblings I can go stay at if I have to use a tether. And I don't have a lot of money on me. Most I can scrape up to 500 to 800, and that's just due to having a support system of my family members. But I would like to continue to keep working and maintain my place of being until this case is resolved and go forward from there, Your Honor. And I want to say I apologize to the court for the misunderstanding just from what I'm being accused of. So I know I'm not charged yet, I'm not guilty yet, but I just apologize for being in front of you due to late rent to now you looking at me like, Mr. Smith, what's going on? So I just wanted to give my apologies to you.
Okay, thank you very much. But you have been charged, but you haven't been convicted. And the court will also note that Mr. Smith made the statement that he paid the rent to Your Honor, but I can tell you that this court has not received any of the rent payment. I myself have not received any rent payment, but the rent was to where's the Green Trees Apartments? Is that where it is?
It was, Huntington Housing. Remember
Okay.
y'all broke it down in segments for me. Y'all, that's why I'm still allowed to live there now, y'all honor.
Oh, I think, was this last week? And then there was like weekly payments or
Yeah,
something?
and it was all, yeah, the church helped me pay it off. Saint
Okay.
Joseph, yeah.
Okay, all right, so no, so I do recall that now that you said that. So, okay. Sir, where is it that you work?
I'm at Amazon in Romulus. I just started out there last week before the holiday and everything. I passed my drug test and I passed the background check of 7 years of having a felony. So I should be starting, I already got an email on my phone saying I'm good to go to work, so I'm supposed to start this week, Your Honor.
Okay, so, the matters from 2022 that, out of Detroit that were dismissed, who is the complaining witness in those domestic violence matters? And stalking?
In 2022,
Yes,
I had a sibling. I was living with a young lady, and it was a misunderstanding, and she just wanted me out because I was.
Mr. Smith, just answer the question. Who was the person?
Oh, what was the question? You just
Who was
said
the
who is the person? Charlene Parker.
Okay.
okay, all right, so not Ms. Jones, okay.
No, not Ms. Jones.
And you're not on probation or parole anywhere?
Nowhere, Your Honor. Nowhere.
There's another one out of March of 22 out of 36 district court where you were released with no prosecution, but the other matters, you were charged, but then those were dismissed. 2 domestic violence charges and a stalking charge. And that was an individual with the name of Miss Parker.
Ms. Who?
Miss Parker, is that what you said her name was?
That was the same person. That was the same incident.
Okay. And sir, your matter from 2017, you said it was sent, it shows you were sentenced to 3 years, 4 months to 5 years. How much time did you serve in the Michigan Department of Corrections?
I did 4.5. I did 3.5 years. I did 4.5, 3.5 years. I did 40 months altogether.
Okay.
I've been off parole and probation. I haven't had no parole or probation since I want to say 2021. I want to say, and I've been clean for 4 years, but it's 4 years since I have had my conviction since 2016.
Okay, so if you're tested right now, sir, what's in your system?
Probably just marijuana. I hit a joint prior to the night of my incident, of my misunderstanding. I don't do drugs at all. I don't even smoke weed like that. Sorry, I don't smoke weed like that. I just hit a joint every now and then with probably friends or company. You will not find any drugs in my system.
All right, and is Miss Jones the mother of any of your 6 children, sir?
No, she helps me with them. I receive my children every weekend, and she receives her children every probably 2 weekends. So I receive my children every weekend for my visitation to see them, and she helps me with those. I have 2 girls that come over and 1 son.
2 girls and 1 son.
That comes over. My other 3 children is, I want to say, out in Ohio.
Okay.
I haven't saw them in a year. She's married now and moved on, so.
Okay.
But I do have 6
All right,
children.
Okay. And Detective Lyles, did you want to address bond?
Yes, Your Honor. Your Honor, I believe 20,000, 10% would be sufficient bond for this case. Obviously, this is not a first offense based on the charges or the alleged charges. A couple of things. Mr. Smith has 4 active warrants for his arrest out of Detroit. All the warrants are labeled from 2017. I'm aware that Mr. Smith has stated that he hasn't been in any trouble for 8 years. However, I should point out that he's been in prison for 4 of those 8. And when he has been out of prison for 4 years, he committed an offense in 2022, which was dismissed for domestic violence. I understand it was under a different victim. However, that's an inaccuracy in his statement. Additionally, Mr. Smith does not abide by the court's orders due to the fact that he's had warrants since 2017. He's been out of prison for 4 years and he's not made any attempts to take care of those warrants. Based on the severity of this incident and the victim being injured to the point to where she's afraid of him and is asking the state to press charges because she's afraid of what he may do to her, I think a GPS tether and no contact order is appropriate for this case.
All right.
Okay, may I speak to my lawyer?
Mr.
Hold on, sir.
I apologize.
Detective Miles, what are the nature of those warrants, please, from 2017?
They're Detroit traffic warrants. It looks like open alcohol in a container, or open alcohol in a motor vehicle, improper plates, unregistered vehicle, and no ops on person.
Okay, all right, thank you. Okay. Based on the nature of the charges, the seriousness of the offenses, the habitual offender designation in these matters, and to protect the public as well as Ms. Jones, and to ensure Mr. Smith is going to appear in court, the court's going to order a $25,000 10% bond with the following bond conditions. You are not to have any contact with Ms. Jones. That's phone contact, text message, email, social media, third party, any delivery service, any postal service, anything of the like. You may not contact her from the jail, whether it's by phone, by tablet, otherwise. You may not have anybody else contact her from the jail. Do you understand all that, Mr. Smith?
Yes, ma'am.
You're not to enter the premises at the apartment in the event you post bond, with the exception of one visit to obtain your personal belongings, so long as you're accompanied by a police officer. They will give you directions as to how that would occur. You don't go there and then call the police. You cannot go there unless you have the police with you. You're not to possess or consume any alcohol or drugs that are not prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those, sir?
No.
You are to have a GPS tether through the Wayne County Jail, house arrest, may work with proof shown to your tether agent. Any questions regarding the bond conditions?
Yes.
Okay, what's your question, sir?
Your Honor, the most I can get to you is $1,000. It'll really be busting my head wide open to try to find $2,500. I can get $1,000 and I will commit to your tether. I will, Your Honor. I will, with no problem. No issues, Your Honor. I can get y'all $1,000. And I don't have a problem proving that this is a big misunderstanding. And making sure I make it to court. Please, if I can get my bond lowered to $1,000.
So those are the conditions of the court. That's the bond of the court. You also have a surety there, sir, so that could maybe be an option for you, but the court's keeping the bond as it is.
What's cash and
Thank
surety? What does that mean?
Do you want us to explain that, Your Honor?
Yes, that's fine.
So did it go lower?
All right.
Okay, thank you, Your Honor. Have a good day.
Thank you, Judge.
Have a good day. Thank you.